Good day, everyone. Eric Olsen from Helps YouTube Live on December 16th, 2025. Glad to have you here today. My name's Eric, attorney for 46 years now, founder of Helps. Helps is a national law firm. We represent seniors and disabled persons who owe debt they can't afford to pay. And our most important message to seniors is that your Social Security, your pension, your disability, your VA benefits, your retirement income is protected by federal and state laws. Can't be taken from you. It's available for your needs, and you don't need it to pay debt you can't afford to pay. Lawmakers protected that money for you because they don't want seniors to go without their needs. They want them to have food, medicine, heat, a place to live, transportation. So that's why it's safe and it's protected. The title today is, Do I Need to Show Up at Court? Something like that. Okay, so because someone on a YouTube channel on senior living, they made a comment, if someone takes me to court and I'm on Social Security, do I need to show up to court then? That was their question. And if you have questions, put them in the chat and I'll get to them. But I'm going to, just a minute here. It looks like I got a little problem with my computer here. I'll get this straightened out real quick. Yeah, I got it straightened out. So do I need to show up to the court? Okay. A lot of times I'll tell people, hey, you don't need to go to court for whatever reason. And some people make comments, well, you have to go to court, or if you don't go to court, they're going to get a default judgment. Okay. Well, let's talk about that. Let me get my computer oriented here. It went off for a second. Here we go. Do I have to go to court? Okay. Some guy made a comment. He said, well, if Eric's wrong, if you don't go to court, they get a judgment, or they get a default judgment. Well, okay. Obviously, if you don't owe the debt, you can always contest the debt. Okay. If you get sued, they're going to send you, someone's going to deliver what's called a summons and complaint normally, and it's going to describe what you need to do if you're going to defend the lawsuit. You have to do it within so many days. Sometimes you have to pay a little fee. Normally you would have to pay a fee. And sometimes they have a fill in the blank if it's small claims. Otherwise you'd have to fill out a form. Or you'd have to draft an answer yourself and deny the claim. And you put in, with the basis of your denial. But for the vast majority of seniors that Helps assist, if they get sued, it's on a debt that they owe. Okay, they owe the debt. Now, some people or some seniors might want to engage in, trying to defend a lawsuit, and there's websites that tell you how to do that. But the vast majority of our clients aren't really interested in doing that. They don't want to get involved with trying to defend a lawsuit. They want to stay away from the court system. They wouldn't know what to do. But let's say you did defend the lawsuit and you went to court and you owe the money. What do you think is going to happen if you owe the money? The other side's going to be able to prove that you incurred the debt and you owe the money. They're going to get a judgment against you. Now, if you want to contest that and try your luck on that, you can. But the vast majority of our clients, they're not interested in doing that. And if they, it'd just be frustrating for them, and you'd lose anyway. So, there might be an exception. Someone plays the game or system. Maybe the other side gives up and doesn't pursue the lawsuit. But most of our clients aren't interested in trying to defend a lawsuit. So the question is, he says, if I'm on Social Security, do I need to go to court then? If you owe the debt, no, you don't need to go to court. What's going to happen? Well, they're going to get a judgment. Okay. And you might say, well, gee, it's a default judgment. Well, a judgment is a judgment is a judgment. A default judgment is just a type of judgment that they get when you don't do anything. But if you defended yourself and you lose and they're still going to get a judgment, it's the same. There's not any difference between a default judgment and a regular judgment when you go to court. They're both judgments, okay? And if your only income is Social Security, if you've been listening to me or know this channel, you're going to understand that your Social Security is protected. No one can garnish it or take it from you. There's very few exceptions. The only exceptions are occasionally the IRS could offset 15% of your Social Security, but very rarely is that an issue. Normally you can get on currently not collectible status. About the only other, student loans aren't actively trying to set off Social Security now. They're not doing that. The Department of Education has stopped doing it. And maybe they'll start it again, but right now they're not doing anything about seniors that have Social Security attempting to take any of their Social Security. Then, so what else? Well, I guess if you owed past due child support, it's possible for them to offset as much as 60% of your Social Security, but we run into that so very rarely, it's hardly even worth mentioning. So, do you have to go to court? Well, the answer is no. If you read the summons or complaint you get sued with, it says you can file an answer if you want to file an answer. If you don't file an answer, it just explains they're going to get a judgment. Sometimes when you get sued, they'll have a date and a time for go to court. But if you read it carefully, that's only if you're going to defend the lawsuit. So for the vast majority of times, seniors really don't need to worry about go to court. Okay? If they get a judgment, as long as you keep the balance in your bank account less than twice the amount of federal benefits you get each month, that sum is protected in your bank automatically by your bank without you having to do anything. So I'll describe that. If you get $1,500 in Social Security each month, that sum times 2 is protected by your bank in the event someone sued you, got a judgment, and they tried to garnish your bank account. You may never get sued, but if you did get sued, then they're going to have to know where you bank, find out where you bank, and that's not easy to find out. But if they did and they filed a writ of garnishment on your bank account, then the department in the bank that deals with garnishments, they're going to examine your account. They can determine where the money came from. If it came from a federal source like Social Security, they times that times 2, and they protect that sum automatically without you having to do anything. So now, if you happen to have more than that in there, they could offset the excess, but you could file a challenge to garnishment or claim exemption to get the excess released from the court. Occasionally that'll happen with one of help's clients. Not very often, because most of our clients, when we talk to them, we train them that they should keep the balance in their account less than twice the amount of Social Security if they're sued. Now, if you haven't been sued, I don't care how much you have in your bank account. No one can take money out of your bank account unless you've been sued. Okay? So now, is there a time when you would need to go to court? Well, occasionally I'll talk about, if someone sues you and gets a judgment, occasionally a judgment creditor would file some paperwork asking you to answer some questions. And then normally you would need to do that, but there's nothing to be scared about. They can't take anything from you. And then you may have heard me talk occasionally about what's called a debtor's exam. I don't really like to talk about that, but that's where an attorney that sued you and got a judgment asked the judge to issue an order for you to come into court to answer questions about your assets. It happens really rarely. When it happens with a helps client, we normally contact the attorney that asks for the debtor's exam and say, hey, here's proof their income's protected. Do you really want them to come in? They don't have the money to pay you. And most of the time they'll go ahead and say, okay, you don't need to come in. They'll have the court release the requirement to come in. But if you were to require it to come in, it's nothing to be scared of. We explain to you, but it happens so rarely, it's hardly worth talking about. It just doesn't happen that often. But for some reason, it strikes fear in people's hearts. And that's the whole purpose of helps. Helps was founded so that if you ever had a question or concern, you could always call us on the phone. When you enroll in helps and you're a client, you're literally our client forever. Not just one time, not just for 2 months or three months, literally for the rest of your life. As long as you want us to help you. The cost of helps, maybe 1 out of 6 or 7 of our clients get our help for free. Those that pay a very minimal amount. The most a person would pay normally would be $40 for 24 months, $20 for 24 months, then free thereafter. or $30 for 24 months, $15 for 24 months, free thereafter, or $20 for 24 months, $10 for 24 months, or free thereafter. So it depends on your household income. Remember, when you enroll in HELPS, you can stop paying the credit card debt and these other loans that you have. You don't need to pay them. If you have a car you can't afford, you can let it go back, an RV, or stop making it on a timeshare. No matter what it is, you don't need to worry about your debt. And then you call and talk to us. Okay? So I think there's some questions here. Let me see if I can get to them before we go on. Okay. If my 90-year-old mom passes away, I won't qualify for an apartment. Is there anything you can do to help? That's kind of a broad question, but I'll try to answer it. You know, there is Section 8 housing. If you're a senior and you have lower income, you can sign up for Section 8 housing. There's a waiting list, although we do have an email that tells you parts of the country where there is no waiting list, or it's a shorter waiting list, okay, where you pay usually a quarter to a third of your income for your housing. But you can always call and go over your situation. Remember, when you enroll in HELPS, you're no longer going to need to pay this credit card debt. So you're going to have that much money, extra money available to you. Okay? So this guy, David asks, I'm 60 days behind on my credit card debt. I have a job offer. If I accept it, how do I approach my creditors to stop garnishment of my wages? Well, unlikely you're going to have a problem. I'll explain why. I mean, it's possible, but I doubt it. Okay, first off, you haven't been sued, okay? You're just getting a brand new job. There's no place a creditor can really go to find out where you work. I mean, it's not on your credit report. There's no way they're going to find out where you work. It's going to be unlikely. And then it depends on where you live. In some states, South Carolina, Texas, don't even allow garnishment. In every state, federal law protects a minimum of $217.50 net per week in wages, $435 every 2 weeks, or $950 a month. Okay, is protected from garnishment. And then a lot of states protect more than that. And like I said, Texas and other states, a few other states protect your wages from garnishment completely. Like California, I think it's like almost $600 or $700 a week. It depends on the state, but a lot of states protect more than the $217.50 is what the federal government protects. That's been in effect since 1996, and I don't know if it's going to get changed. I think what the Congress decided, they said we're going to leave it up to the states to see if how much they protect in wages. Okay, and occasionally the states will raise the amount, but a lot of states just stick with the federal amount. So if you are garnished down the road, what do you do? Well, you know, we could recommend a bankruptcy. We don't file bankruptcy, but we'll tell people about it if that looks like it would solve the problem. Maybe you lower your hours so they can't take any money out. But we just don't run into a problem with our clients that decide to work or to go back to work with them being garnished. We just don't have that come up. So if my wife is on Social Security and has a judgment, how long will that be active and at risk of her accounts staying to the limit? Okay, so if someone sues you and gets a judgment, it depends on state law how long that judgment's good for. Typically, it would be good for 10 years, and sometimes maybe less in a few states. And then some states, if it's good for 10 years, the state will allow the judgment creditor to renew that for another 10 years and maybe renew it again. It depends on the state. But once again, if your income is Social Security or a pension, retirement income, you're judgment proof. It doesn't matter if they get a judgment; they can't do anything to you. To your wife, you don't need to worry about it. Okay. Now, and then once a judgment gets old, when one of our clients gets sued, client gets us a copy of the lawsuit. We just need the first 3 or 4 pages. We're going to send a letter to the attorney that sued you. Now, it doesn't mean you're going to get sued. Some guy asked yesterday, will eventually all my creditors sue me? The answer is no. I mean, it's theoretically possible, but, no. You normally a minority would sue you. But it doesn't matter if all of them or most of them or just a couple or none of them sue you because you're judgment proof. Okay? Which means they can't take your money, your Social Security. It's protected in your bank account, as I explained. And they're not going to go after your assets. I mean, what do I mean by assets? Well, let's say I talk about a home, maybe a car, maybe your personal possessions at your house. Virtually every state has what's called exemption laws that protect a certain amount of equity in different types of property. So much equity in a home, so much equity in a car. It is not the practice of consumer judgment creditors like credit card companies who get judgments to go after a person's property. They normally don't do that. It'd be very unusual. You just don't do it for a lot of different reasons. Maybe you own it with your spouse. Who owns, what interest do you have? How can they take it? They can't. So, you shouldn't worry about a judgment. Okay? Okay. Oh, you missed a story. Okay, I'll try to tell a story, maybe tomorrow. Pictures on the back wall. Well, that's interesting that you should mention that. Okay. Well, that's a good idea. I'll take a picture a day and explain it. Here's one. They all have meaning to me. My mom, this was in my baby book. It's a little boy in Belgium after World War II. And he's got a look on his face, if you could see it, is pure joy because he has a new pair of shoes. He has a new pair of shoes. Yeah. If you look at his shoes that he's wearing, they're kind of worn out. And I've always liked that picture. Anyway. And then the other picture, remind me tomorrow and I can show you. Some of them are pretty interesting. Okay. So Rico says, I have some charged off credit cards outside of a couple of letters, no harassment so far. It's best to preempt further noise with helps. Yeah. Ceases that are just wait for the inevitable. Well, there's no inevitable. I mean, it's, they're going to call you eventually. It depends. I don't know what it's up to you. People. We've tried to make helps affordable so anyone can enroll, and we're always available to answer your questions. So, so if you got charged off credit cards, the next step is for them to refer it to a collection agency, and then you'll get calls from them. You may eventually get sued. Just because you enroll in helps doesn't mean they're still not going to try to collect from you. You could still get sued. Okay, that happens, of course. And they may turn it over to a new debt collector. And the nice thing about helps, if you get a notice from a new debt collector, you're going to call us on the phone and you're going to send us a copy of the new notice or get us the name and address and account number. We're going to send a notice to that new debt collector so they leave you alone. Okay? Jim in Tennessee, even if they get a judgment, don't the interest keeps going up, the debt never goes away? Well, yes and no. First off, there is a statute of limitations requiring them to sue you within a certain amount of time. Otherwise, they can't sue you. Usually that could be 5 years, 6 years, depends on the state. But so what if they get a judgment and the interest keeps accruing? You're not going to have to pay it because your income's protected. You could owe $1,000 or $1,000 million. You're not going to have to pay it. You don't need to worry about it. Okay? Someone is suing me for defamation. An attorney said the charges don't equate to defamation. The plaintiff wants $11 million. My income is protected. Do I have to go to court? Well, you can defend yourself, but if you're on, someone's probably crazy who's suing you, who's doing that. If they know you're a senior on Social Security and a pension, they pretty much know you're uncollectible. If they get a judgment, they can't do anything to you. So you really don't need to worry about it if you don't want to. And you probably couldn't afford to defend yourself anyway. And you might say to yourself, well, Eric, I don't owe the money. And I agree with you. And you can defend yourself if you want. We don't represent people in court, but if you decide you don't want to go through the hassle, if they get a judgment, they can't collect from you. Okay? If I get a judgment in New York, how long is it good for? Well, okay, I don't know off the top of my head. You can just Google, how long is a judgment good for in New York? And it'll search that, and it's going to tell you. Probably 10 years, and it probably can be renewed for another 10 years. That's typically what the law is. Okay? So I just got a note here from one. I want just a mention. Someone, I'll mention. I talk about occasionally timeshares. I talk about them fairly. If you got a timeshare and you don't want to keep it, you can stop making the payment on it. You can stop making the payment. You can let it go back. They're not going to sue you. It wouldn't matter if they did sue you. It's not their practice to sue. They may send you a letter asking you to sign it back over to them and requesting you pay $1,000 or something like that. You could sign it back over. Don't give them any money. But no, and you don't need to hire someone to defend yourself from a timeshare. If my wife with a judgment is awarded $20,000 from an accident and wants to pay down a second mortgage, can it be intercepted by the judgment in Florida? Virtually every state protects a judgment for pain and suffering from an automobile accident. So, no, you could do that. You could pay down that judgment or pay down the second mortgage in Florida. Shouldn't be an issue. You can always call and talk to us. We talk to you about it. So here's the deal. If someone has a judgment against you and they're trying to get money from you, they have to file a writ of garnishment. And normally the writ of garnishment will be filed against your bank account. They have to know where you bank, which is not easy to find out. And then when a bank gets a writ of garnishment, they get it. It comes in the mail. And they say they open up the mail at 10 o'clock in the morning. And then the person who's assigned to, he looks at the letter and he looks at your account. And if your account has less than twice the amount of federal benefits in it at 10 o'clock when they look at the writ of garnishment, they throw that garnishment away and they let the person who did the garnishing know, hey, this person's income is protected. There's no money there. So let's say at 2 o'clock in the afternoon, that money gets deposited in your account. Now it's way over twice the amount of your federal benefits you get each month. Are you going to lose that money? No, because they've already looked at the garnishment. And in virtually every state, there might be an exception, but a garnishment on a wage on a bank account is just kind of a one-time thing. They look at it when they get it. Okay, be too difficult otherwise for the banks, and so they just require them to look at it at the time. Okay. So an existing client's called us. She was getting calls from Advanced America. Okay. So she enrolled I guess early December. And letters had gone right out early December to this Advanced America. Oh, actually, we sent letters out on 11/18. Okay. And I explained to her, okay, so the Fair Debt Collection Practices Act, which is a law that helps operates under, applies to debt collectors, not original creditors. Now, there are 7 states where it applies to original creditors, but it applies to debt collectors. Now, Advanced America was the original creditor, so for them to continue to call her, they're not breaking the law. Now, normally when someone enrolls in helps, you're going to give us all the people you owe money to, including an original creditor, credit card company. And it's our experience that they're going to stop communicating with you by phone, but an original creditor like a credit card company may still send you a bill, okay, which they legally can do, but they're going to stop calling you. But if you were called by any of these creditors and they ever did get through, and you're a member of HELPS, you just tell them you're represented by HELPS. You give them our name and number, and tell them not to call you anymore, and just hang up the phone. Don't engage in any conversation with them. Okay. Debt is sold to a different debt collector up to 20 years in Michigan. Well, there's a statute of limitations for collecting a debt with a lawsuit in most states, in almost all states. And for a credit card, that might be maybe 6 years from either the date when the debt was incurred or when a last payment was last made. But if it's beyond that, then legally they can't sue you. But technically, they could still call you on the phone, or they could send you a demand letter. I've seen a number of demand letters where they ask you to pay the money, and then at the end of the letter, they'll say something like, by the way, we can't sue you, but please pay this debt. So, yeah, I've talked to people that have gotten collection notices for debts that are over 20 years old. It's pretty uncommon. Pretty uncommon. Person contacts us from Massachusetts. Age is 79, and they're $1,500 in Social Security, and they rent where they live. And it says, I'm reaching out on behalf of my mother. She fell and broke her hip, needed surgery. During this time, I took over making her bills were paid on time. I came to find out that she was embarrassed and had racked up over $30,000 in credit card debt, and also consolidation loan, etc. She really cannot afford to make the payments. Yeah, her only income is $1,500, Social Security. I'm trying to figure out who can help her and where we go from here. She's on Social Security and has about $20,000 in her IRA. Okay, IRA is protected. No one can take it. You shouldn't use an IRA to pay old debt, because that IRA is your nest egg. You can use that for your basic needs, things that you need, but you don't need to use it to pay an old debt. Once it's gone, it's gone. So we called her back. Found out she was had a consolidation loan from TD Bank. And anyway, explained to the daughter and the mom how her income was protected. She didn't need to pay the debt anymore. And she enrolled in HELPS. And we sent a letter to her creditors, and they're going to leave her alone. Life's going to be a lot easier for mom. Not going to have to worry. So this person contacts us from Georgia. They get $1,218 in Social Security. Defaulted on a loan with Comedy Bank and is now being sued for $2,700. On top of that, it looks like he totaled his car on December 12th. And doesn't have a vehicle. But his wife has a car. They're considering selling the home. The wife is working and isn't in the lawsuits. Yeah, so he doesn't need to worry about the lawsuit. I'm not sure about what's going to happen on the car, but the insurance will pay it. But if he ends up, if he ends up owing money on the car, he's not going to need to pay that. And if he doesn't want to have to deal with the creditors or worry about this lawsuit, he can enroll in HELPS. We'll send a letter to Comedy Bank, their attorney, letting him know that his income is Social Security and he can't afford to pay it. Okay? So this person contacts us from Texas. He got a default judgment. And he got a letter from the attorney with, he calls interrogatories, or questions that he needs to answer. And it's supposed to be notarized. And he's worried that his wife is going to be responsible for his debt. No, she won't be. There's lots of medical bills. The home is in the wife's name. So, first off, what we would have told him that, this interrogatory, these questions you're supposed to answer. In some states, if they get a judgment, the attorney will send you a form under state law that requires you to answer certain questions. We help people with that. It's pretty simple normally because there's nothing you have they can take, okay? Sometimes it asks that the form be notarized. For a lot of our clients, they can't get out of their home or they can't get to a notary. And a lot of them don't bother with having it notarized. I can't ever recall a time when the other attorney on the other side ever refused to accept it or asked that it had to be notarized or insisted on it be notarized. Okay? He's worried that his wife's going to be held responsible for his debt. No, she's not. Now, in some states, you have what's called community property states. That means that technically, if you have a debt or an asset, the spouse is named your spouse, even if they didn't incur the debt, they're liable on the debt. Or if they have an asset, they own the asset with you. But it's not the practice of credit card companies to ever sue, even in a community property state, the other spouse. They don't do it. So he's not going to need to worry about his spouse being responsible for the debt. Plus, he lives in Texas, which has a lot of protections for debtors from creditors. And then his wife's, he's got serious medical issues. The home is in his wife's name. If he passes away before her, then she's the home. It's going to be fine. And we also discussed wage protections. I'm not sure if he's working, but if he is in Texas, all his wages are protected. So that's what we do. We explain, and we give you information on why you're going to be okay. Okay. I talked to this lady yesterday, an existing client, and she had an Audi with a $700 payment, and her son was making the payment on the car. Then the Audi had some mechanical issues. It's a hybrid, which means it's part electric. He went to the shop for 4 months, and he didn't pay and he wasn't able to make the payment for those 4 months because he didn't have the car, and she didn't have enough money to make the payment. And they're probably upside down, which means the car's worth less than what they owe. And she wanted to know, well, can he keep the car? He would need to pay 4 payments to get it caught up, $2,800. And I talked to her for a while, and I said, does it really make sense for him to do that? Part of the problem was the car was financed by the credit union. Okay, and then she owed a debt to the credit union as well. So I explained to her that whether she realized or not, the credit union had what's called a cross-collateralization agreement. Not only did she owe the money she owed on the car, but the credit card debt would also be owed against the car. So if the son kept paying that car and it was paid off eventually after 4 years or whatever, then the credit union is probably going to say, well, we're not going to give you the title until you pay the credit card debt. And then I said, that's a lot of money going out. $700 for the car payment, probably $200 for car insurance. Maybe the son doesn't really want to keep the car. And she said, well, he did tell me that if it went back, that would be okay. And I said, that's probably the smart thing to do, let that car go back. And in the end, that's what she agreed. She said, yeah, that's right. And she said, he doesn't live with me. He lives somewhere else. I said, well, he can probably hang on to it for 3 months or so and get replacement transportation. So we discussed how repossession would work and how they would eventually sell it. They would probably sell it for less than what she owed. Then when she got a letter saying what she owed, which is called a deficiency notice, get that to us. We'll send a cease and desist letter, and they're not going to bother her. So you're going to be fine. Okay? So this person contacts us from Pennsylvania. Okay, it says back in 2022, she was evicted from her apartment and they finally sued her for the remaining amount owed. She lives with her daughter and pays half the rent. And we sent her an email about Section 8. She would like to get her own apartment someday. She thought her car was stolen, but found out it was impounded by the police. She couldn't find it for 3 months. Her car was impounded, failure to pay for a parking permit. She did call the police. They asked her if it could have been impounded. She said, no, I don't think so. And the police didn't do anything more. And apparently they didn't let her know that it was impounded. She reached out to their insurance company, and they found the car that it was impounded. She called the impound lot. She owes them $8,000 and wanted to charge her $250 just to remove her personal possessions. Oh my gosh. She couldn't afford either. She lost everything inside the car. Well, this woman talks fast. Okay. We reviewed how her income is protected, and she has other debt and enrolled in helps. A good chance to talk about car repossessions and what happens. Now, in this case, it was impounded. I've been in practice a long time. I've dealt with a lot of cars that have been impounded. There was one company I knew of. They had 2 lots. One on one side of town and one on the other side of town. And then they had all these signs up everywhere, if you're parking illegally, they would tow your car. And so when they would get calls to tow a car because it was parked incorrectly, or even if the police had them pull the car away, they would take the car from where they were to their lot that was farther away. Now, I know this for a fact because I ended up suing these guys. So they would go an extra 10 or 15 miles or whatever it was to go across town to deposit the car across town. Why? Because then they could charge a higher fee, mileage fee. And that's what they did. And I'm sure they're not the only one that does this. I've been involved in a lot of these these car tours, and a lot of them they're not scrupulous. And they're going to charge her $250 to remove her personal possessions. That's a new one to me. But I always tell people, if you've got a car at risk going back for repossession or not, whatever, make sure you keep your personal property out of it while it's at risk. Because you can't trust the person who's going to repossess the car. I used to get calls when I was doing bankruptcies, and they'd put the call through. Eric, there's a client on the line, and their car's getting repossessed. And I had instructions that car was to come, that call was to come immediately to me. So the client would get on the line, and I tell him, I say, "Where are you right now?" And I said, "You go stand in front of the car right now, or get inside the car immediately." And they start talking. I said, "Don't talk. You just do what I said. Stand in front of the car." Because most of the time, these people are going to file bankruptcy. They were going to keep the car. And we could keep that car in a bankruptcy. There was a type of bankruptcy we could file to cure the missed payment. But if it was repossessed, it became a big headache. So I would say, they'd want to talk. I said, no, just stand. A repossession guy cannot break the law to repossess a car. If you're inside the car, he can't pull you out. If you're standing in front of it, he can't touch you. Once in a while, the cop would come, and the cop would say, tell the person they have to move. And I tell him, and I could hear him talking. I say, "You tell the cop that your attorney's on the line. The attorney says that it's a civil matter and that you're not moving." And then I'd hear a bunch of talk in the background, and pretty soon the client would tell me, he says, "Well, the cop left and the repo guy is leaving," because they know they cannot break the law to repossess the car. But anyway, so I guess two can play that game, but repossession guys can be pretty brutal. But in this case, her car was being towed, and then they charged her $8,000 for 3 months storage. Now, did it really cost them $8,000 to store that car for 3 months? But she couldn't defend herself on it. Hopefully she owed money on that car and it didn't make sense to keep it. Okay. Okay, this person writes in, they say, I have outstanding debt that I have not been able to pay. The sheriff tried to serve me court papers today, but I was not home. I receive a monthly sum for VA disability, and I also work. I am married, and my wife stays home with our twin girls. I don't really know where to turn, and you guys helped my wife years back. Well, we'll talk to him. Sheriff tried to serve court papers. When you get sued, normally you're served with papers, and it can be either a sheriff's deputy that is a civil deputy that's assigned to serve papers. He's not a criminal deputy. Or it can be a private party. When one of our clients is sued, we ask you to get us a copy of the lawsuit. We send a letter to the attorney that sued you, let him know that your income is protected. You're not going to pay the debt and don't need to worry. Now, in this guy's case, I don't know how much he makes. But we'll talk to him, and he may need our help or he may not need it. Depends. So this guy writes in and he says, my father died last year at age 94, blind and poor. And just here lately, his debt collectors are trying to get me and my brothers to pay his bills. I told my brothers, don't pay them anything. It's not our debt, and just hang up on them. Good for you. And tell them they're, won't repeat it. All his kids are seniors. Yeah, his dad's 94. They're probably in their 70s. And are having trouble paying their own bills. You're not responsible for your parents' bills. But, a creditor could try to intimidate you into thinking you were. You don't need to pay it. Okay? Person writes in and said, I've stopped paying most of my credit cards and now I received a summons. They've been sued. I'm married, but I don't have his name on the cards. It's my name only. My husband and I keep our finances separate. We even have separate bank accounts. Even the summons was handed, but the summons was handed to my husband. There were 2 copies. Both were in my name. And when handed the summons, the person handing the summons to her said one was for my husband. Does he have to respond if his name is nowhere on the summons? No, because he hasn't been sued. And the person that handed you the summons, they never read it. They didn't look at it. They didn't know. They assumed that both husband and wife were being sued. And when they serve, they can serve both parties by serving one. Okay? So no, if the husband isn't being sued, there's no, and the person who handed you the paperwork didn't read it. They didn't know what they were talking about. So this person contacts us from Idaho, age 70, $20,000 in credit card debt. And the cards are current, but the limits are being reduced. He doesn't know how to live life without credit cards. Previously, he worked as a debt collector. We explained his protections of his income. He didn't need to worry. We told him what it would cost to enroll with HELPS. Reviewed in depth how HELPS works. We talked about how to improve his credit score, 720 credit score. He says he wants to be prepared for whatever comes next. That was on December 5th. Then he calls back on December 9th and he said he's worried about 1099-Cs. Now, what's a 1099-C? Okay, well, that's a notice that if you get from a creditor, if you're behind on a debt and they write it off as uncollectible, or if they're going to get turned over to a collection agency, the law requires them, if it's over $600, to send a notice to the IRS called a 1099, which tells the IRS that you didn't pay that debt, therefore it should be income for you. Okay? Now, he's really worried about this because apparently when he was a debt collector, he talked to people collecting debt and he used the fact, you're going to get a 1099 if you don't pay this debt. So he was really worried about that. Okay? 1099 probably going to be a problem. I'll tell you why. Well, if your income is just Social Security, you're probably not even required to file tax returns. But even if you were required to file tax returns and you get a 1099, if you're insolvent, which means if your debt exceeds your assets, In other words, you have more debt than you have assets, then there's a form you can file, and you're required to file tax returns. There's a form you can file called 982. You click the second box saying I'm insolvent, which means my debt exceeds my assets. But even if you did owe taxes because of a 1099-C, most of our clients could get on what's called currently not collectible status with IRS. IRS normally aren't too aggressive about pursuing people for 1099-Cs. Okay? It says here he's thinking of waiting until the new year to stop making payment. Well, you can do that, but sometimes I'll tell people when they call us and they're thinking about enrolling in helps is, if you're going to roll, making any more payments after today is like flushing money down a toilet. Okay, you can stop making the payment. You can stop making the payment immediately. You can enroll later, but maybe it doesn't make any sense to make any more payments. But he's still worried about this 1099-C, which he doesn't need to worry about. We talked about debt consolidation, debt management, and the difference between them and helps. What's the difference? Well, one difference is, with rare exceptions, they're never going to tell you the things that you're going to hear from helps, the fact that your income is protected, you don't need to pay the debt. Instead, they're going to sign you up to make payments. What does that tell you about them? They withhold the most important information you deserve to know, the fact that your income's protected and that you don't have to pay the debt. Yeah. So it looks like this person eventually decided to enroll. Oh, wait a minute. No, they called back again on December 12th. He wanted to tell us a story. Talked with one of our attorneys. We read the paragraphs, quoted the fees, and we enrolled him. He doesn't want to give the creditors to us right away because he doesn't want to receive any 1099-Cs right away. He doesn't need to worry about a 1099-C. Discuss he didn't file a tax return last year, and he doesn't need to this year. So it's an issue he doesn't need to worry about. But he just wants to worry about it, but he doesn't need to worry about it. Okay. Anyway. If you have a question, you realize you can always call us, even if you're a client. The whole purpose of helps, if you're worried or scared, you pick up the phone and you call us no matter how often. So this person made a comment on one of our videos, or it was on a senior living video. And it says, okay, all they said was this, but when you die, they will come after your assets. Well, not really. Okay, I'll explain why. The seniors that we help generally don't have an estate when they pass on. They're living from check to check. Their personal property isn't worth a whole lot. Personal property like furniture and that kind of stuff, and kids going to distribute that amongst themselves. Costs more money to try to sell it than it'd be worth. Now, if you own a home and you own it jointly with your spouse and you die, then it's going to go to your spouse. Or if your kids are on the title, it's going to go to your kids. So there's very few seniors that we work with that end up really with an estate that would require money be paid to creditors. And if you own something jointly with someone with survivorship rights, then when you die, that property passes on automatically to that other person. Like a title to a car, for example. And therefore, a creditor it wouldn't be entitled to any of that equity out of that property. Okay? Okay, this person contacts us from Indiana, and they got a letter from an attorney saying that they'd been sued. A lot of bankruptcy attorneys subscribe to a service, lets them know if someone's been sued, and they'll send a letter to someone saying, "Hey, you've been sued. You can see me." He's buying a home. We explain how his home is protected. And how his vehicle is protected. And how his income is protected. Looks like he enrolled with HELPS because he didn't need to worry. This person contacts us. He says, yes, credit card debt. I was screwed over by National Debt Relief. It's a debt management company, and canceled with them. Ready to enroll. Was ready to enroll. Apparently he saw some of our videos. Person contacts us from okay, no, that's all right. Okay. So this person contacts us from Washington. This is a little bit long. I don't know if I want to do that one. See if there's questions here I need to deal with here. Okay, here's a good one. How can you rebuild your credit in 2 years when the debt will stay on your credit file for 7 years? It won't stay on your credit file for 7 years. No, your credit is based on your recent credit history. It shows on your credit. Sometimes a credit, we have a program that we give to people. It doesn't cost them anything. That have been part of HELPS for 90 days. It's called 7 Steps to a 720 Credit Score. You can rebuild your credit within 1.5 to 2 years. And one of the first steps in that program is if there's errors on your credit bureau, on the reporting, you can have those errors removed. So when they report, when the original creditor reports that the debt is, not a good debt, that's it. Okay, that will stay on your credit report. But your credit number is based on your recent credit history, so you can rebuild your credit. Okay, on our YouTube page, HELPS YouTube page, we have a video that talks about this program, how it works. Also, judgments don't appear on credit reports anymore. Lawsuits don't appear on credit reports anymore. Tax liens don't appear. Okay? So you can get your credit back. Not all of our clients are interested in doing that, but some of them are. Okay. So it looks like it's been an hour. We'll have YouTube live tomorrow, same time. And me and I'll talk about something on the wall back there. There's a couple things that might be interesting for you. So thanks for participating. Thanks for your questions. We always ask to press the like button, share what HELPS does with others. A lot of seniors need this help. I have no idea it's available. So until tomorrow, I'll see you tomorrow. Everyone have a great day. God bless. Bye. Happy holidays too, of course.